Hello and welcome to episode 108 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away today. In today's episode, I'm going to tell you about the Supreme Court's recent decision striking down mandatory minimum sentences for accessing and possessing child pornography. And this was done on the basis of what are called reasonable hypotheticals. Just a trigger warning that that segment will be upsetting for some people. It's upsetting for me. So feel free to skip that segment if you like.
Plus, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about my trip to Parliament to testify on Bill C-8, which would give the Minister of Industry the power to cut off your internet and phone service if she believes you pose any threat to the telecom system. So the reason I wanted to talk about this is not just because I think Bill C-8 is bad and needs some improvements. Listeners already know that because we talked about it in a previous episode, but I thought this would be a good opportunity to give listeners an insider's view of how our laws do get made in Ottawa and how we can help to ensure they don't harm civil liberties. So if you're like me, you probably were aware that bills have three readings, with the first being pretty perfunctory, the second involving debate, and then the third one on a bill that has sometimes been modified by a committee. But you probably didn't know much about what happens in those committees. So that's what I want to sort of explain today because it's surprisingly interesting. So Bill C-8, which is something the CCF raised our concerns publicly about a month ago when it was up for second reading. We had people write to their MPs if they had concerns that they shared with us. More than 1,000 people did that. And after it was sent, after one went through second reading, it was sent to this committee called the Standing Committee on Public Safety and National Security. A couple weeks back, we got invited to come and answer some questions on the bill, and it's not entirely clear who invited us there. It could have been one of the MPs, or it could have been the committee clerk himself. So what this committee is essentially a group of 10 MPs who review legislation, policies, and spending plans related to public safety and national security, and try to improve those bills before they become law. This particular one is chaired by a Liberal named Jean-Yves Duclos, who was a minister in the Trudeau government. And in total, it has 4 Conservatives, 5 Liberals, and a Bloc MP. And the first thing you'll notice, it was really obvious when you enter the room, is that there's no NDP members there. And that's because they're not unofficial party anymore, and they don't get to be on committees. And a lot of committees in this particular parliament have this setup. They have 5 Liberals, 4 Conservatives, and 1 Bloc member. And this actually matters a lot because when there's a tie vote in committee, so let's say just the Liberals vote for something, the chair by convention has to vote to maintain the status quo. So motions get defeated all the time. They can't pass if there's a tie. So essentially, it takes the Bloc siding with either the Conservatives or the Liberals to decide any particular vote. So with C-8, I already knew that there's members of the Conservative Party who are sympathetic to our position and more willing to hear us out than the Liberals were, but I had no idea what the Bloc member thinks, and frankly, I still don't know, although she did say something to me. So, okay, back to the day of the hearing. So I get up, fly from Toronto to Ottawa on an early morning flight, and I arrive just in time for this 2-hour meeting. The beginning of the meeting, like all of these meetings, is a fight about some procedural issue, and I was trying to figure out what exactly that was, but it turns out the MPs themselves didn't even really know what they were fighting about. To the best of my understanding, committees considering 2 bills at the same time. So C-8, this cybersecurity bill that could cut off your internet, as well as their border security bill, C-12, and there was a dispute about whether the minister would come 2 different days for an hour on each bill, which is the tradition, or whether he would just come for 1 2-hour meeting. And the Conservatives were upset that the Liberals wanted to do this as like 1 2-hour meeting, probably because appearing on 2 days might get them more time to ask the minister questions, might get more coverage in the media, things like that, although I'm honestly not really sure. So the point is, there's always these procedural fights, and that's because the Conservatives' goal is often as opposition to slow down the bills, while the Liberals' goal is to push them through as quickly as possible. So they moved to the hearing of the witnesses. There's only 50 minutes left at that point for 8 witnesses, which is not a lot of time. So I raised my concerns for 5 minutes and then wait for questions. And my concerns are basically that Section 15.21 of this bill would give the minister this dangerous power to cut off phone and internet based on any threat to the telecom system, which of course includes all of our internet, phone, and radio infrastructure. Even if it's not a serious threat or a systemic threat, it could be something as small as someone that may be planning to do some sort of attack on the Prime Minister's website. And this is really concerning because obviously if you cut off internet for people, you're interfering with their free speech, their free association, their right to peaceful assembly, not to mention all of the other things we do online. And, some people say this is far-fetched, but everybody said it was far-fetched to think the government would cut off people's bank accounts in the middle of winter without due process, which obviously they did during the Emergencies Act invocation. So I offered my thoughts, and then came the questions. Conservatives had good questions that made me think they're seriously considering some of the amendments we proposed to reduce the risk of civil liberties, which is great. Then a Liberal MP asked me a question. It was essentially, some other experts said you're wrong about this. Like, how do you respond to that? And she really didn't like my answer because she gave me a look of absolute disgust afterwards, which is, I think she's doing for the cameras. And that brings me to another part of the committee, which is that they can be a bit of a show, a bit of a circus with, MPs like her trying to discredit witnesses who raise good concerns and prop up witnesses that they think are right. Christine famously testified in a Commons committee where they asked her if people should be allowed to use the N-word, and
He didn't ask if they should be allowed. He asked if it's okay. And obviously the answer is no, that's not okay. But
right.
I don't think you should go to jail.
So thankfully I didn't get that question, and it was over pretty quickly. The block didn't ask me anything, which is interesting because, like I said, she holds so much power. But she did come up to me afterwards and shake my hand and say that what I had to say was très intéressant. So I don't know what that means other than she's
It means
thinking
very
about it.
interesting. You're
Yeah,
French.
très intéressant. Yeah, so that was good, I suppose, but we still don't know whether she'll support amendments if the Conservatives put some forward. But it gives me some hope that we can preserve civil liberties in committee, even if the bill starts out not great. So we'll see what happens. Christine, coincidentally, you've been invited to also testify at committee this week. This is my first time testifying in person. You're going to be doing it online. Um, why don't you tell us a bit about that? What do you plan to say, and what are you hoping to accomplish?
I hope I'm asked about the N-word again. I
Well, it does
mean,
make great
like
social media clips.
I
So,
mean, what a ridiculous experience at the last committee. That some of these committees are more interested in actually getting into the guts of a law and figuring things out, and some of them are more about a performance. And that committee for me was a very much just like parliamentarians wanting to get clips for social media. And I wish I had known that because I went in with some, nice ideas and thought they wanted to talk about them. And that was not the purpose of my appearance. So I'm going to be testifying this week about Bill C-9, which is the Combating Hate Act. I do think that this committee is more thoughtful than the last committee I appeared before because we're actually considering a piece of legislation. So what I'm doing is I'm proposing, first of all, I think C-9 should be withdrawn. I think that it will reopen a whole lot of questions and likely lead to findings of unconstitutionality. I think that the bill is very vulnerable to litigation, which we might bring if it passes. So I've proposed first withdrawing the bill, and if they don't want to withdraw the bill, I proposed some specific amendments that could be made. And if you want to hear what those are, I'm going to post them on Thursday on the CCF's website. The whole brief I have prepared is going to be posted, and you can watch my committee appearance at 3:30 tomorrow. I do think, as you discussed, the power is in the hands of the Bloc right now. And what's interesting is that the Bloc seems to have a really specific concern with this bill. They want the exemption in hate speech laws for religious speech to be removed. Right now, there is a defense in Section 319, sub 3 of the criminal code that says you cannot be convicted of an offense of willful promotion of hatred if you are engaged in a good faith expression of a religious opinion. And there has been a little bit of case law considering this defense. The existence of the defense has been crucial in the finding of constitutionality of 319 sub 2. So without that defense, it was considered in Keegstra. Without the existence of the defense, we don't know if this law would be upheld. And second, there's been some case law considering what good faith actually means. And I'm going to talk a little bit about that in my remarks as well. I'm sure I'm going to get asked questions about it because the Bloc has been systematically asking every single witness if that defense should be removed. I do not think it should be. I think it would make the law a lot more constitutionally vulnerable. I think the defense is a good thing. And they've also been asking about a specific remark made by a pretty radical imam from Montreal about what he characterized as a prayer for the extermination of Zionists, which I think is appalling conduct and despicable to pray for the extermination of a people. But I do think he was not charged under the law. And I think that you cannot charge someone for prayer. He's not specifically telling other people to commit violent acts. He's asking God to destroy his enemies, which, I think that's protected religious expression, even if it's not good. The Bloc member also asks if this is appropriate in Canada. Of course not. But the criminal law doesn't deal with what's appropriate or not appropriate. It deals with what's criminal and what's not criminal. It deals with actual threats of violence. And a prayer, even if it's a terrible one, isn't violence. So I think that's what we're going to be getting into on C9 tomorrow. So check out my committee appearance if you're interested. And I'm sure we'll put a YouTube video up as well on our channel. I'm going to talk now about my news headline, which is the Supreme Court's most recent case about mandatory minimums for possession of child sexual abuse imagery, also called child pornography. And, I said at the top that I'm going to have a trigger warning. I know a lot of people find trigger warnings kind of lame, but I still think you should have one in this case because I'm going to explain the details of what happened in this case. It is a criminal case involving child sexual abuse. And a lot of the details are really, really upsetting. They're upsetting to me. You might not want this information in your mind. And so that's why I'm going to give you the choice to, skip ahead 5 minutes. So the case is called R and Senneville or R and Nod. They're two defendants in this case. So both cases involve two men, or both cases involve men who were charged with both accessing and possessing child sexual abuse imagery. Nod was also charged with distributing child sexual abuse imagery, but it's not the distribution charge that is at issue in this case. So Senneville is 28 years old, or was 28 years old when this case started. He pleaded guilty. He admitted to possessing 317 images of child pornography, and 90% of those images were of young girls between the ages of 3 and 6. And the images were of violent sexual assaults, including penetration of 3 to 6-year-olds and sodomizing 3-year-olds and 3-year-olds, 4-year-olds, 5-year-olds, 6-year-olds. Horrific. Nod was in his 30s, and he also pleaded guilty to possession and distribution of child pornography. He had 274 images and videos of children aged 5 to 10 also subject to violent sexual abuse, including fellatio, penetration, and sodomy. This is really hard to hear. It's really hard for me to say, but it is important to know the actual offenses in this case. There is a mandatory minimum sentence of 1 year's imprisonment for both the offenses of possession and accessing images of violent abuse like this. And I think if you asked most Canadians, what do you think the penalty should be for possessing these type of images? Remember, this is a 3-year-old, a toddler, being subjected to extremely violent sexual abuse. It's an image of a crime. And I think most would say a year isn't enough. I asked my husband, he's not a lawyer, I asked him, what do you think the penalty is for possessing images like this? And he said, I would guess between 5 and 10 years imprisonment. It's 1 year is the minimum. So where am I now? So both defendants challenged the constitutionality of these mandatory minimums after pleading guilty. The sentencing judge found that the appropriate sentence for Senneville was 90 days served intermittently, so like on weekends, for the possession charge, and 90 days for the accessing charge. The judge found that the appropriate sentence for Nod for the possession charge was 9 months imprisonment. For both defendants, the judge found that the mandatory minimum of 1 year was grossly disproportionate with what he thought the appropriate sentences are. And he found that the 1 year is unconstitutional. It violates the Section 12 Charter guarantee to be free from cruel and unusual punishment. Now, on appeal, the Court of Appeal actually increased Senneville's sentence, finding 90 days was not sufficient. Increased it to 1 year because of, quote, the nature of the images involved. Nod's 9-month sentence was maintained for the possession charge. The question for the Supreme Court in this case was if those mandatory minimums are constitutional, and the Supreme Court said no. The 1 year and the 9-month sentences are maintained, but the law requiring a minimum of 1 year was struck down. And there was a really fiery dissent where the dissenting judges held that this minimum was constitutional. The majority reason was on the basis of what we call reasonable hypotheticals, although I guess now we're supposed to call them reasonably foreseeable scenarios. And these hypotheticals are actually found in a lot of the Section 12 case law, including cases like R. and Noor, R. and Lloyd, and R. and Bissonnette. And the court in this case upheld the use of reasonable hypotheticals as part of the Section 12 analysis. So the question in a reasonable hypothetical is not how does the law apply in this case, but rather how might it apply in another case if a mandatory minimum sentence is broad and covers a wide range of circumstances. The courts find that a sentence is constitutionally vulnerable if it leaves no choice but to impose a grossly disproportionate sentence on certain offenders. And the reasonably foreseeable scenario in this case was, what if it's not about a 28-year-old man looking at images of toddlers being raped? What if it is a bunch of teenagers sexting? What if a 17-year-old girl sends a nude image to her 18-year-old boyfriend who then shares it with a friend? First, let's start with saying that that is bad behavior also. Like, you should not be doing that either. An 18-year-old who shares an image of his girlfriend with a friend, that is worthy of condemnation also. But how likely is that scenario to actually lead to a charge? And if that were to happen, what alternative remedies might the court have in that case? Why is the only option to compare this toddler rape scenario to teenager sexting? Very different scenarios. Why and use the very extremely different scenario to strike down the law? Why is that the only option? The dissent really slammed this approach. The dissent held that if you're going to use a hypothetical scenario, it needs to be, quote, constructed with care and in a manner consistent with the adversarial process. The claimant can take the situation before the court as the starting point and then change features of it, provided the scenario still has more than just a remote connection with the actual facts of the case. And the dissent also found that the claimant can take an actual reported case as the starting point and then adapt it until it has more than a remote connection to the case. The dissent position is that basically the proposed hypothetical needs to retain a sufficiently close connection with the facts of the case. And the acceptable scenario cannot be too remote. And in this case, there's just too big a difference between teenagers sexting and collecting toddler rape videos. So I think if you polled the average Canadian, they would find this decision appalling. They would argue 1 year is not enough, that there should be higher penalties, and they just do not understand why, and I don't understand either, why the court would choose such a remote, different scenario as the comparison point for such a heinous crime. Josh, one of the issues here is that reasonable hypotheticals get used all the time in this case law. It looks like it's not going anywhere anytime soon. What do you think of this outcome?
Yeah, so you're right. Reasonable hypotheticals aren't going anywhere anytime soon, and that's just because the Supreme Court has done it so many times that for stare decisis purposes, it's really hard for the dissent to say we shouldn't even engage with reasonable hypotheticals. But I think that is what should happen because this is not a good way to decide cases. Like, I understand why the majority is concerned about that hypothetical where, an 18-year-old and a 17-year-old are sexting. Like, I get that, why that would not, necessarily warrant a year in prison. But why not wait until that, if that ever leads to charges, because there is such thing as prosecutorial discretion. They don't have to charge if it's not in the public interest. But let's say, this scenario does happen. A mother is really mad. She goes to police. She pressures them. They do charge, and for whatever reason, the Crown doesn't throw that out. That's when you should decide whether that mandatory minimum is unconstitutional in that scenario. Not in this case where very, very clearly a year is totally reasonable and probably not enough. So I don't understand why we can't just wait for those particular facts to come before the court. But what do we do now? Well, one thing Parliament can do is they can carve out that scenario where it's teenager sexting, which still is a crime and still is wrong, but maybe doesn't need a year in prison automatically, and change the law, and then maybe it will be upheld as constitutional. But you might at this point also use the notwithstanding clause, which is what Pierre Poilievre has said he's going to do, and I think would get a lot of support from Canadians if he says we need to overturn this with the notwithstanding clause. So there are a couple options to fix this, but ideally there wouldn't be reasonable hypotheticals at all. And before we move on to bad legal takes, I just want to read you a passage from this that I think is particularly galling. So when we look at cruel and unusual punishment, what we're supposed to decide is the unusual part is, like strange punishments like torture.
Torture, yeah.
Yeah. But the cruel part is supposed to be, it's only cruel if it's so excessive as to outrage standards of decency, as you mentioned, Christine. But the question is always, what's so excessive that it's going to outrage standards of decency? Certainly 1 year for, what happened in these cases is not going to outrage standards of decency for the vast majority of Canadians. But
in fact, the 90-day sentence is more likely to outrage standards of decency.
That one literally turns my stomach because I know, 90 days, a 90-day sentence is actually
intermittently. So it's like on weekends.
Yeah, and something I learned while working for the Crown is that any part of a day counts as a day. So what they do in these intermittent cases is you come in at the very end of the day on Friday, and if it's before midnight, 1 minute before midnight, that counts as a day. And then Saturday, Sunday are a day. And then if you stay overnight till Monday morning, it's another day if you're a minute past midnight. Wow. So it's really like, 6 months of your weekends, which is not enough
For those crimes.
for those
Oh,
crimes.
horrible.
So that would outrage the standards of decency way more than a 1 year minimum sentence. But what the court says here in the majority is this: the sentence must shock the conscience or be abhorrent or intolerable. But this is not assessed based on what the court believes to be the views of Canadian society. It's rather assessed through the values and objectives that underlie our sentencing and charter jurisprudence. In other words, it needs to shock the conscience of judges, not of Canadians. So, okay. So judges judges are the ones that get to decide and not Parliament what's shocking to the conscience, not, people who are elected. So that shocks my conscience. But anyway, I'm ranting now, Christine, so maybe it's time to move
I
on
mean, this
to
case makes me rant. This case is appalling. It's so
yeah,
disgusting. It's really upsetting.
it's terrible.
But speaking of disgusting, I'll turn to my bad legal take, which I'm giving to my local movie theater, which is called Kingsway Theater. I encourage no one to go to this theater. It is at Bloor and Royal York. I've actually never been there because I don't like the way it looks. In my opinion, it looks like it needs some maintenance. But I recently learned that the theater owner, under the name of the theater itself, loves posting on X. And the things they post include a response. Someone posted an image of a Jewish home being vandalized with Nazi symbols like a hooked cross or the swastika. And in response to that, this theater owner wrote, well, it is the proper symbol of Zio-Nazis. He's written repeatedly on X telling Jews to, quote, go back to Poland. In response to many accounts that defend Israel, he has said that they are paid by Israel and writes things like 7,000 shekels have been deposited into your account. He regularly replies to Black people on X by saying, go back to the plantation. He calls Israeli diplomats at the UN subhuman devils. He's repeatedly called people things like quote, murderous, filthy, vile, Hasbra fake Jew scumbags. He uses gay regularly as a slur. He says we should actually listen to what Putin says, among many, 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 many other things. I mean, this is a movie theater down the street from my house. It plays kids' movies. So I thought that most people would like to know in my neighborhood that this person holds these views. So I posted on my neighborhood Facebook group, drawing attention to these posts, saying that I will not support a business like this. And the theater owner, I guess, somehow is in this Facebook mom group. Weird. And he screenshotted it and he reposted it on his own Facebook page. Okay, like, sure, tell more people how terrible I think you are. He screenshotted it, posted it, and said, commented on the irony of me condemning his words while also being a free speech advocate, which I, of course, am. I'm an advocate of free speech. So, look, I guess it should already be taken as a given that this man is an idiot, since only an idiot would post these things. But his comment that as a free speech advocate, I shouldn't be criticizing his views is also a bad legal take. Me saying that his ideas are disgusting is also free speech. It's actually how free speech works. Someone says something, we say something back, and I can use my words to condemn him, to tell people to stay away from his business, to warn people that he holds views like this. And that isn't censorship. It's me repeating his own words. It's me drawing attention to the things that he says. It's how the marketplace of ideas works. And I think that the market should punish him. And I'm happy to use my free speech to tell people I think that. So, Kingsway Theater, you're on notice. Bad legal take, bad also like human takes. Like maybe don't use language like that or hold despicable views like that. Josh, what's your BLT this week?
So mine is also about free speech, and it goes to Mark Miller, who Canadians may remember as the former immigration minister who oversaw a very large increase in the number of new neighbors in Canada over the past few years. He was
Also,
actually,
Also, famously a bestie of Justin Trudeau. He was in his
That's
wedding
right.
party.
That's right. So he was actually shamed this week in the budget, which states that the government is taking back control of immigration, and I guess it's taking it back control from Mark Miller, who is still a member of their own party. But anyway, my BLT has nothing to do with that. It's actually something Miller said in his role as chair of the Standing Committee on Justice and Human Rights, which is studying Bill C-9. Christine, you're going to go speak to that committee this week. He said in this committee meeting, in Leviticus, Deuteronomy, Romans, other passages, there's clearly hatred, for example, towards homosexuals. I don't know if the concept of good faith could be used. Clearly, these statements are hateful. They should not be used as a defense. And then he asked Derek Ross of the CLF, the Christian Legal Fellowship, what's your notion of good faith when there are passages of religious texts that are clearly hateful? So Miller's essentially saying that the Bible is clearly hateful and that quoting somebody should lead to, in some cases, convictions for hate speech, like going to jail for quoting the Bible, as long as it's, also inciting hatred. That's horrifying for free speech, and it blew up on X as one would expect, but Miller doubled down. And, many religious people, I want to point out, they quote these parts of the Bible without any hatred in their hearts. They, in some cases, say they just believe that that this is how God views it. It doesn't necessarily mean they're hateful. Famously, the Westboro Baptist Church, which says absolutely horrible things like, well, we don't need to quote them, but they say horrible things about gay people. Some of them have come out later and said, like, we actually don't hate gay people. We just think God hates them, and so we're trying to save them by having this position. And obviously, I think they're wrong. That should go without saying. But it's not the type of thing that should land anybody in jail. It's not the type of thing that free societies should be doing. So Miller saying this highlights exactly what I was saying before, which is that the Bloc now has a lot of power because getting rid of this defense is their bugaboo. So bad legal
It's
tape
also,
to
I would say, so Derek Ross, I watched that committee appearance. Derek Ross pushed back and he said, there is nothing in the Bible that is hate speech. The Bible is not hateful. And it is important to know that those portions of the Old Testament are a description of the old law, and that executing gay people would be contrary to the teachings of Jesus. So Miller should probably go back to Sunday school as well. In addition
All
to
right, so
going back
bad
to
legal
Con
take
Law
and
101.
also
Bad religious take.
because Miller came out and said, as a Christian, this is what I believe. It's like, oh yeah, I'm sure you're a Christian. Anyway,
He
okay,
might be, but he should relearn some basics.
exactly. Well, okay, that's enough of the show for today. So as usual, we will ask you to rate us, review us, and subscribe if you haven't already. And you can also support our work by subscribing to our YouTube channel, following us on X, or signing up for our Freedom Update newsletter at ccf.ca. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.